Good morning. Can I welcome everyone to this, the 9th meeting of the Justice Committee in 2013. Please get everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. No apologies have been received. And David McCletchie has given his apologies. Taking item 1, decision in taking business in private. We're asked to decide today whether to take 3 items in private, because all 3 items relate to consideration of draft reports. Can we therefore agree to consider draft reports on an inquiry into purposeful activity in prisons under item 5 today and at future meetings, a Public Bodies Act consent memorandum under item 6 and subordinate legislation under item 7? Now, I'm just wondering, because of arrangements today, how the committee feels about shifting the order. 2 of the reports have to be signed off today. That's items 6 and 7 on the agenda. Item 5 doesn't have to be signed off today. Can I give the committee's agreement to perhaps take 5 last? It doesn't mean to say that we've made any decision, just simply we can go through that last. Is that all right? You're agreed? Yes. Thank you very much. Inquiry, item 2 on the agenda, inquiry into the effectiveness of provisions of the Entitlement Petition Scotland Act 2003. This is our final evidence session of our inquiry into the effectiveness of the provisions in that Act. We will hear from 1 panel of witnesses today, and I welcome to the meeting Professor Kenneth Reid from the University of Edinburgh, Professor Robert Reddy from the University of Glasgow, and Lionel Most, Property Law Committee at the Law Society of Scotland. Can I thank you all for your written submissions? And I have to say that some of us were in your tutorials. I'm glad Professor Reid doesn't remember me, because I think I ended up with conveyancing headaches, if that's true, after tutorials. But you're very welcome, and bear in mind that we are lay, so we can follow what is being said to us. Can I have questions from members, please? Jenny.
Thank you, Convener. Good morning. Thank you for being here. I would like to tackle section 53 first, because I'm particularly interested in its efficacy. We've got your written evidence, and I think there are points to say it's perhaps not as well drafted as it could be, and has implications that perhaps it shouldn't have. Can you perhaps, all 3 of you, take us through your feelings on section 53 and what perhaps might be done to improve it?
Can I just say to the panel, if you just indicate to me you wish to speak, your microphone will come on automatically. So who wants to pick it up first? Professor Rennie.
It is almost unintelligible. It is very difficult to teach, and it is very difficult, more importantly, to advise clients as to what it actually means and what their rights and obligations are. It is a very good example of hasty legislation at an amendment stage to cure a particular problem which has had unforeseen consequences. But it does not work as it stands.
And how would you like it to work, Professor Rennie?
Section 52, which is the preceding section, and which was the section which was the only section in the bill as it left the Scottish Law Commission, enacted what effectively had been the common law through decided cases up to the legislation. It proved quite difficult to enact common law through hundreds of cases into sections, but section 52 is as good a job as you would get in enacting what the law was prior to the 2003 Act, which was, if you live in a property which is surrounded by other properties, all subject to the same title conditions, then by and large you can enforce these conditions against your neighbour. Section 53 says the same. There must be a common scheme of burdens, but it also allows enforcement rights where the properties can be said to be related. And the definition of related properties is not clear. And the decisions at the Lands Tribunal and in the courts after 2004 indicate a problem in definition, because in some cases the Lands Tribunal has said there is no common scheme. In other cases it says the properties are not related. Section 53 simply does not work.
Professor Reid.
Right. If I can just add to that, I mean, I entirely agree with everything that Professor Rennie has said. I think the problem goes beyond drafting. I think the drafting of Section 53 is a little bit unhappy, but I don't think that's the main difficulty. The main difficulty is it's trying to do something which is almost impossible to do by legislation, which is that by means of a general rule, it's trying to provide clarity to title deeds which are extremely varied in type. And I think that even if one recast Section 53 and tightened up the drafting, it would help. But I think it wouldn't solve the fundamental problem. Just add a couple of other things. One is to say that what we're talking about here is a provision that only applies to real burdens created prior to the abolition of the feudal system of land tenure, which took place in 2004. So this is a problem not with burdens created since 2004. The legislation there requires the deed which creates the burdens to say who's got enforcement rights. So there's no difficulty with new ones. This is a historical problem, and it arises from conveyancing practice as it was before 2004, which was often not terribly good. And it also arises from the problem of dismantling the feudal system, because a lot of these burdens were feudal burdens in origin. At one time, they were therefore enforceable by feudal superiors. When the feudal system was abolished, the question was, what happens to these burdens? Do you get rid of them? Do you provide enforcement rights? And Section 53 is an attempt, in effect, to transfer enforcement rights from the feudal superior to neighbours. Yeah, that's all I'll say at the moment.
I understood it, so that's excellent for me. Mr. Most.
From our point of view in the Law Society and Property Committee, and as me as a practitioner, we look at the practical implications of these things. And the examples that we get on the committee of Section 53 issues tend to be translated into neighbour disputes. And people will use the law sometimes to, if they don't get on with their neighbour, I'm not having that in my scheme sort of thing. And if that is the effect of the legislation, then it shouldn't be there. You know, legislation should not be there to encourage simple neighbour disputes. So
do we simply delete or amend?
That was my question. How would the Act stand without Section 53?
Without Section 53, I think that there would be some losers. Some neighbours would lose out. But I don't think we have enough evidence as yet. I think possibly we're too early. We don't have that many examples of issues to judge whether you want absolutely nothing or a clean draft. Clearly, my two colleagues are, I think, in favour of abolition. We at the Law Society, as I said in my report, we have differing views. Some people think that it does protect some people, but in the main, we feel that it encourages neighbour disputes.
Yes, Professor Reid, yes.
Question to the professors, yeah.
I agree.
Which one, Professor Rennie? I have two professors.
Okay, will I just speak for a second? Sorry. There's a sort of competitive problem with Professor Conveyancing at Glasgow University. If I can...
Long-standing.
Long-standing. If I can...
Mr. Morse, between you, or as I did here...
No, that would be worse.
If I can just say a couple of things, and then... I'm sorry, convener. We'll get through this eventually. I think the real problem with Section 53 is uncertainty. Because the provision is, of its nature, very general, very hard to apply to particular cases, what it means is that when you're trying to advise a client as to who can enforce those burdens in their title. So when people buy a property, they get their title deed. The title deed has a whole series of burdens in them. And the question is, what is the status of those burdens? And there are two issues. The first one is, can anybody enforce these burdens? In other words, are these just dead burdens, burdens that died with the feudal system in 2004? That's the first question. And the second question is, if they're not dead, who can enforce them? And the two questions are related, because unless neighbours have enforcement rights, nobody has enforcement rights, and therefore the burdens are dead. And in order to work this out, you have to apply, among other provisions, very often, Section 53. And when you try to apply Section 53, you very often, usually, don't get a clear answer. And so you have to say to a client, I don't know. This may be enforceable by everybody in this housing estate. It may not be. I'm not sure.
Can I just say that following on from that, very often there's you have a kind of practical solution, and the solicitor, the practicing solicitor, will sit down with the client and say, do you want to build the garage? Do you not? Go ahead and take a chance. And that's not really a satisfactory solution.
See, Professor, is that, Professor Rennie, you content to?
The fact of the matter is that Section 53 was not in the Law Commission bill. The Law Commission and its advisory subcommittees took years looking at feudal abolition, title conditions and tenements. Presumably they came to the conclusion that Section 52 was all that was necessary. So my starting point from that is that the people who looked at it most closely and over a continuous period of time came to the view, or did not come to the view, that a Section 53 would do any good. What in effect it may have done is give people enforcement rights in pre-2004 title conditions which they did not have before that legislation. That must mean that other people who were not subject to these conditions before 2004 suddenly, without their consent, became subject to these burdens, a matter which could have given rise, of course, to Article 1, Protocol 1 ECHR problems. So I am in favour of the radical approach. Section 52 represented the law as it was. These are burdens which were there before. I see no reason why they should have any change imposed on them.
So, Professor Rennie, to answer the same question that Mr Moss answered, do you think the legislation would stand without Section 53, or should it be amended?
I think it would stand without.
And Professor Reid, do you agree with that?
No, I don't think I do agree with that, not in a simple way. I don't myself think the issues can be solved sitting around this table. I think they're far, far too difficult. They have to be solved. I think the message that needs to go back is that the status quo is not acceptable, that Section 53 simply doesn't work in its current form, and the issue has to be looked at again. My own experience, I spent 10 years at the Scottish Law Commission doing law reform, including the Title Conditions Act. I know how extraordinarily difficult the issues are, and I don't think they can be solved simply by three people, or more than three people, having a discussion at the moment. I think that it has to be looked at again. There are difficulties about simply abolishing Section 53, and one of the obvious ones is human rights issues, because the effect of Section 53 is to confer enforcement rights on a lot of people. If it was simply deleted, these enforcement rights would be extinguished, and there are issues, human rights issues about doing that.
But they didn't.
Sorry, Professor Rennie. Yes.
But they didn't have them before, Kenneth. So if they didn't have them before, and we gave them in error, why are their human rights affected?
Because they have them anew, I think, is the problem.
Professor Reid, if it needs to be looked at again, who are you suggesting by? Because now this is legislation. I think it's within the hands of Parliament to do the post-legislative scrutiny and do any revision to the legislation. So how are you suggesting that we proceed? I'm just looking for a practical kind of way forward on this.
I'm not sure I'm the right person to advise you on that. I mean, in my written submission, I make a number of suggestions about what could be done. I set out three possible options. But I don't indicate any preference for any of them, because, as I say, I think the issues are actually too difficult. I don't think this can be done without somebody or somebody sitting and looking at this a lot more carefully than we can do it this morning.
Mr. Moss, sorry, beg pardon.
So, I mean, for example, it could go back to the Scottish Law Commission, would be one option.
Roderick, do you want in as a supplementary in this?
Precisely the point I was going to raise, whether the panel thought it should go back to the Scottish Law Commission to look at, because we're in danger of going round in circles where everyone agrees there's something wrong with Section 53, but we can't work out a solution.
Certainly, I would favour that. I think that would be a good way forward.
Sorry.
Yes?
Yes, I would certainly think from a practical viewpoint, if we got certainty, that would certainly be helpful to the profession.
I think we have exhausted Section 53. Have we? I've got John Finney, then John Lamont, and then Roderick on. These are all separate questions, right?
Thank you, Convener. Morning, panel. Mr. Most, it was about your evidence, and you mentioned the option of introducing the right to buy the land owned by the maintenance company. Could you expand on that for us, please?
Well, this was just a discussion that we had at the committee, at the property committee, where similar to it was just an idea that people had, similar to the concept of the community right to buy, that it could be, this is something, again, that we can't fix on a day like this, but something that could be looked into, the possibility of the owners of the development forming a corporate vehicle, a special corporate vehicle, to acquire the land, and they'd have to compensate the owners, obviously, and they'd have to take on the obligations of the current proprietors, but the ownership of that corporate vehicle would be within the owners of the various houses in the relevant scheme.
As part of these discussions, was there any mention of planning law and the ability of local authorities to impose conditions? Because it seems that, certainly I'm of the view that local authorities don't wish to take on the responsibility for maintaining that. They're very happy to take the council tax from the residents, but was there any discussion around any planning conditions that could be imposed on any developer?
No, there wasn't any discussion. I know that we all know that for the past 20 or 30 years, councils have not been keen to take on green space area at all. There was, I think, there was a practice in Falkirk for a while where they imposed a bond, this bond I was talking about in my evidence, on the owner, on the original developer for 10 years or something to provide a fund for maintenance. But certainly, no.
And do you see an increased role for local authorities at all?
Sorry?
Do you see an increased role for local authorities in resolution of this issue in any way?
I don't think so, really. It's not, I understand it's not within their core services that they have to provide to the community, and leisure areas. And to be honest with you, in the areas where a good development that is maintained well privately tends to be better maintained than a good development which is maintained by the local authority.
Well, I don't know whether they'd accept that, but...
That's anecdotal. Anecdotally, let's put it that way.
Can I just push on that issue then of the drainage system, which could be seen as a real imposition on anyone buying the... you don't see that the local authority has an obligation for that, because...
Well, see, from our point of view in the property committee, we look at the practical implications, and our view was that the owners in the development had a closer relationship with that particular land than anyone else.
One part of the land and out the other part of the land, the obligation either side being the responsibility of the public sector.
You mean the sewers? Yes. And the drains?
Is it not? It's Sister John, is it not the case that when, my understanding is the local authority takes over, for instance, a road, it's because the general public use it. That's the principle in which they operate, whereas the common land round a development is not generally for public use, but only for the use of the people in that community. I think that, is that not the principle in which local authorities operate? Or am I wrong about that? That's the principle, yes.
That's correct, yes.
Yes.
I mean, I live in Eaglesham, which is a conservation village, and it has what you might call a common green between the two older streets. That's owned by the local authority, and I have to say it is very well maintained.
Right now, it's going to keep getting well maintained.
That's right. That's right.
Can we go back to right to buy, which you started to raise? That neither professor commented on that, but you looked sceptical, Professor Rennie.
The private maintenance system has developed without really any intelligible structure to it. And there are various models. The historical model would have been that everybody in the estate would have been given a 1/200th, if it's 200 houses, common right of ownership in an amenity area, with a concomitant real burden that they all were due to pay a 1/200th share of the cost of maintenance, and that's the most straightforward way of doing it. And there are no particular title or property law problems with that. The difficulties which have arisen arise because the private maintenance company, generally speaking, takes ownership of the amenity area. Now, as Professor Reid said in his note, you know, if they own it, it's very difficult to get rid of them. You know, what do? You say, well, we own it, but you're also the property manager or maintenance factor, whatever you want to call them. We are taking a vote and we're going to get rid of you. We're going to change because you never cut the grass, you're never there, you're hopeless. That's fine, changes. In come the new factors. But there's nothing to factor. They don't, I mean, the first company still own it. So, as Kenneth pointed out in his note, there would be room for some sort of scheme whereby if you chose to change the factor oblique property manager, then there would have to be some right to buy the land. It doesn't work any other way. I've had occasion to look at 3 or 4 times the type of burdens that are put into titles where there is to be a private firm owning and maintaining an area. It just doesn't work because you don't have a benefited and burdened set of properties. Because if you're burdening the house owners with the obligation to maintain, they don't have any interest in the area. They have no common right of ownership. There's no such thing as a servitude of roaming about. So it's not possible to have the sort of property law real obligation and real right counterbalance that is necessary for that to work in property law terms. It cannot work. And the difficulties which have arisen result in the sort of trying to squeeze in some sort of system into the existing real burden system. And with the maintenance company owning, it is, I think, impossible to do. So if the idea is that private maintenance of these common areas is the best, then frankly we would need, I think, some sort of statutory scheme to make that work.
Sorry, do you want to add?
I would entirely agree with that. I mean, there are, as Professor Rennie says, serious technical difficulties about trying to do what this scheme tries to do. But there is also a more fundamental issue, which is the issue of changing factors. One of the ideas behind the Title Conditions Act was to provide a rule, because previously there had been no such rule, to provide a rule that if a majority of owners in a community wished to change their factor, they could do so. And that was a very important principle. That principle cannot operate for this type of arrangement because the factor or manager is not technically a factor or manager because they're not managing other people's property, they're managing their own property. And so the provision in the Title Conditions Act simply doesn't apply. And I think that's very unfortunate. It means that people who are tied into this sort of arrangement actually can't get out of it. So what one needs is a provision which extends the right to change managers to this type of case. And secondly, as has been suggested by both of my colleagues, there has to be a matching right to acquire for compensation the green area in question, because otherwise, as Professor Rennie says, there's no point in changing managers' factors if there's nothing to manage or factor. You will have to have a right to buy too. So, I mean, I think legislation is needed here. I think this is something which the Title Conditions Act doesn't deal with, and I think it does need to be dealt with.
Sorry, do you mean within separate freestanding legislation
Or
or
by
within
amendment.
this?
But there would need to be primary legislation to deal with this.
Amend this?
It could be done by amendment. I mean, that's a matter of taste, whether you amend it or have a freestanding
Or
legislation.
freestanding.
It wouldn't be complicated. I mean, we're talking about, a couple of sections.
Thank you. Do you want to come back? I've got a supplementary to this, Roger. Is this a supplementary? Well, somebody's ahead of you, actually. Alison got it nipped in ahead of you, and then you're next if it's the same. And Sandra, you want a supplementary in this as well?
If you don't mind.
First Alison, then Roddy, and then Sandra. Thank you.
Okay, thank you very much. It's very clear that you think that the landowning maintenance issue is very complicated and not working well. What I'm interested is what sparked this model in the first place. Where is the real benefit, and why did this burgeon so quickly on the back of flawed legislation? Clearly, there's some benefit to this model. I'm not quite sure what it is for the landowning maintenance company to actually own the land.
I don't think it comes on the back of the legislation. I think it comes on the back of failure, if you like, to be interested in maintaining common area. I don't think in Scotland we have a culture of common maintenance coming together. I mean, you see this in tenements and all over the place. I mean, I get endless opinions to do on people in top flats whose roofs are leaking, and your mailbags must be full of this, and they say, we can't get everybody else to contribute the amount needed. What do we do? And I say, well, it's easy. In terms of section whatever it is in the Tenements Scotland Act, it's an emergency repair. You go right ahead, instruct the roofer, and then sue all the other 7 people for the share. And at the end of 3 years, you'll find that some of them have no money. And by the way, I hope you've got about 30 grand to pay all the lawyers for kicking this off. And by the way, put in a Section 12 notice against all their titles. And that means that if they sell, Now, that's just hopeless. But it's not the fault of the legislation. What it is the fault of the culture or lack of common maintenance ownership culture. And I think to answer your question as to why a private company would step in, I think they would step in because they saw an opportunity. And I think developers would welcome it because it gets it off their plate. And local authorities might welcome it because they might say, well, for the reasons we have already discussed, this is a private area of land. We don't have the money nor the inclination to go in and maintain it. It's a combination of these factors, I would think.
Okay, thank you.
Right, Roddy.
heard evidence last week, gentlemen, from the Office of Fair Trading representatives that talked about the need for a test case for issues in relation to the replacement of land maintenance companies. For the record, in the light of what you've said and the difficulties with ownership, is it your view that it's not a test case that's needed on that, it's a change in the legislation? Yeah.
That's right. I mean, I doubt that under the current legislation, you cannot replace such a manager.
Okay, and the Scottish Government obviously had a consultation in 2011 on this point. Have you got any advice to the Scottish Government as to that consultation and the steps they should now take?
I don't know what's happened to that consultation. The proposals that the government made at the time were really the proposals that we have just been making in the last few minutes. That is to say, firstly, there should be a right in this sort of situation to change managers. And secondly, there should be a right to acquire the piece of land that is being managed. And these are precisely the two changes that need to be made. So, in a way, the Scottish Government has already made these proposals 2 years ago. But I don't know what has happened to them since. No sign has been seen of them that I can detect.
On a shelf somewhere, perhaps.
Could I just raise an issue on a different matter?
No, you can't,
Okay.
because I've got Sandra on the same thing, but you're back in the bottom of my list for something else.
Fine, thank you.
Sandra, the same point.
Yes, Kavina, thank you very much. I just want to ask, I think, a very simple question. Good morning, gentlemen. Would this at all be viable? We have the private company who own the land, and then you say there should be a change in legislation to enable the people who buy the houses to buy the land. And when you look at the situation, the cost, if there's a willing buyer, a willing seller, you've got the cost there. Obviously, individuals within the houses, they also have to have really huge insurance premiums as well. I just want to ask, would this at all be viable to put this forward, to change legislation, a community buyout or buyout? Would it be viable at all? Would people take that up?
Question. In the current economic climate, I cannot see it being high on their list of financial priorities. One would have to say, however, that if people grouse all the time about the fact that the private maintenance company doesn't do it properly, costs a lot of money, and they don't own the land and the private company does own the land, then in a sense you would have to put your money where your mouth is. And if you couldn't come together and pay the cost, then I think you're stuck with it. I don't think you would get away with what one might call confiscatory legislation on the Cyprus model, where you simply say to the land management company, there's been a vote, you don't own this anymore, and you're getting nothing. I don't see that. I agree. I mean, you know, things always come down to money, and it's a practical problem. We can't solve that problem.
Can I just make one practical point in that connection? And there are some schemes in Scotland which are run wonderfully and where people speak to each other. There are some tenements which are sometimes what we call self-factored, where everybody speaks to each other. There are some where people hate each other and they fall to bits. And there are some schemes where the grass grows to 3 feet high and people don't care. I think there is a job to be done in educating the public that they have a duty when they live on a scheme, they have a duty to each other, they have a duty to the common areas, and the people who live down there benefit from that land up there. And that will go some way to amending the culture that Professor Rennie was talking about.
You're a solicitor in practice, so what do you tell your clients buying or indeed selling on one of these estates to alert them to these obligations and to obviously the payments that will be due?
Yes, well, every solicitor has a duty to tell the client what the burdens and the title are, yes. And there is a leaflet, as I said in my as I said in my written evidence, the Law Society has produced a leaflet explaining to people what to expect, and their solicitor will normally tell them that there are common parts, there are grassland, and they have to contribute to that.
And how does that go down? Or how do they respond? Are they interested? You're saying there's an education job to be done.
Yes. Well, and all the solicitors will say it. The people are usually too interested in getting the House to listen.
The very one we word you used, a solicitor will normally tell their clients. Is it not incumbent upon the solicitor to tell their clients that they will have these burdens? Maybe
There
I'm
is a
just picking
duty,
up
that's
being
part of the
pedantic,
solicitor's
You said
job.
normally, and I was a bit suspicious that perhaps, and we did hear evidence that they said not all solicitors did tell them about their burdens, so it is statute that you must tell them they have these burdens.
It's not statutory,
No.
but it is. I think
Advisory.
it is. Professor Rennie is the expert in professional negligence in this area, but I would have said.
Had better introductions.
I would have said it is the duty of a purchasing solicitor to explain title conditions to their client. That's what I mean by no.
Can I just confirm, is it in the home report? Does the home report contain that information?
Contain some of the information. It will contain, for example, if there is a price, if there is a approximate cost of the common charges, it will contain that.
I think in fairness that will be an assumption on the part of the valuer. I mean, a valuer will come and look at a tenement or look at an estate with a green area and will perhaps say, for the purposes of this valuation, I assume that the common area is maintained by every proprietor.
So it's an assumption, but it's not in bold
no,
lettering.
because the valuer doesn't see the titles. No.
Yeah.
But no, the valuer won't, but there's a section at the back which the owner fills in.
Or the questionnaire.
The questionnaire. And the questionnaire will usually say something like, my common charges are £80 a month or something.
Caught in words like normally and usually. I think
Well,
that's...
I say normally and usually because there is a space for it, but it's not always filled in.
Correct. I'm just helping you out there because your words will be taken down and will be used in evidence against you, as you know it will be in the OR. On the same supplementary on this, Graham.
It's a point that Mr Morse made there about changing the culture, and you talked about the purchasing solicitor having various responsibilities. If we are to change the culture, should it not be part of the sales package that makes very clear the responsibilities for the broader spaces that involve this estate or scheme, so that when a purchaser is coming forward, they can see right from day one there are other responsibilities. Otherwise, I don't see how we change this culture.
Well, I did say in my evidence for a new scheme, for example, there ought to be a responsibility on the part of the developer. I put that in my written evidence. There ought to be a responsibility on the part of the developer and perhaps even the planners, just to make this information available. The question of duties on a selling solicitor is slightly more difficult because they're a bit more removed from it. They probably won't get involved until an offer has been put in. They're very rarely involved at the marketing stage. They're not usually involved until the actual selling stage. So I think that's a bit more difficult.
The estate agent then, that, you know, right up at the first stage, everybody's interested in getting the sale and getting the commission and getting the money in the bank. But then, years later, these problems pop up. And sellers who spoke to us seemed to indicate they were unaware of the responsibilities until it became an issue. So if we were able to say right in day one, for all estates and schemes rather than just new ones,
Well,
if you're going to change the culture.
Yes, it could be something that could be explored to educate people at the earliest possible opportunity.
I'm moving on. I've got John Lamont, been very patient, John, and then Roddy with a separate question.
Thank you, Convener, and good morning, gentlemen. My question relates to the enforceability of obligations on homeowners to pay land-owning maintenance companies such as Greenbelt, which I think Professor Rennie mentioned in his evidence. I should probably declare an interest as a former student of Professor Rennie. I was a student of conveyancing and commercial missives, and I blame Professor Rennie entirely for my former career as a commercial property lawyer. So I'm not quite sure who I blame for my current profession, but in your evidence, you suggested that there was no enforceable title condition because at the time when the title condition was created, there was no identified burden property and no identified benefited property. Do you think, as a result of that, that's the reason why property maintenance companies are not pursuing homeowners for non-payment of the obligation, or for non-payment of the sums due that they think they're entitled to through the condition in the title?
I suspect that will be the case, because I know from opinions that I have given that in some cases these deeds are not uniform, where Greenbelt or any other maintenance company are involved. So the views I give on them depend on what each particular deed of conditions actually says. But if after 15 pages of me eruditely going through the deeds and trying to interpret them, I come to the conclusion inescapably that this is not a real burden, then they therefore sue at some risk. At least there might be a possibility of suing on the basis of an implied personal contract if you paid them last time. But from the point of view of suing based on a real burden, or indeed suing the second owner, then that goes out the window because the second owner will not be impliedly bound by contract.
So in some cases, the title condition will have been validly created because of the existence of the benefited and burdened land at the time when the title condition was purported to be created.
No, I cannot see how it is validly created if the maintenance company own the green area. If it's conveyed to the maintenance company, then they don't, the burden has to relate to a benefited property. The benefited property has no connection with the green area. They have no rights over it. They have no right. They may be allowed, and their children may be allowed to wander over it, but they have no legal relationship with it, and that, generally speaking, negatives a real burden. There are, of course, personal real burdens which were specifically created for situations in the 2003 Act, but this is not one of them, and I wouldn't recommend giving a private maintenance company a new category of personal real burden.
So you're of the view that there's some land-owning maintenance companies who are not pursuing homeowners because they've come to the conclusion their advice has been that there's not something that they can rely on, it's not a title condition that they can rely on. Yeah. Okay, thank you.
Yes, Professor.
I just add to that. I do generally agree with what Professor Rennie says. I'm not quite as clear as he is that these burdens are unenforceable. I mean, I think there is certainly a difficulty of the kind he mentions. I think there are arguments one could put the other way, and I think we're still waiting for a test case. But when we do get a test case, I would not be surprised if it decides that these things are simply unenforceable. But I think I wouldn't like myself to say they are clearly and definitely unenforceable.
It's quite dramatic stuff. It means people have been paying when they didn't need to pay. Is that what that means?
Not necessarily.
Ah, right.
No,
I knew I'd get lost at some point.
No, I mean, if the way the court action is raised is there is a real burden, blah 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 blah, therefore you are due to pay, that's one thing. There are other ways. I mean, if you stand back and let them cut the grass, and you pay them the first time, and then they come back the second time and cut the grass, and the third time, and then the fourth time you don't like the way the grass is being cut, or the man that's cutting the grass was cheeky, or whatever it happens to be, and then you say, I'm not paying, there could be argued that there is an implied maintenance contract, but then you would terminate that for the next time. You would just write to them and say, it's not a real burden. I did pay in the past. I now terminate any contractual relationship.
Paid it in error, in other words. in some
Goodbye. You know,
respects.
goodbye. Then, of course, your grass grows. You know. And you don't have the right yourself, because you don't own it, to go in with your own lawnmower.
So it's pay or long grass,
Could
of.
Could be.
Yes, John.
I'll sort of add on to that. I mean, Professor Rennie, you suggested you looked at some title deeds that have these types of conditions in them. What proportion would you say that you have looked at would fall into the category of being enforceable, and how many would fall into the category of being unenforceable?
I've looked at it about 3 or 4 times, so it's not as enormous a statistic. In all 4 cases, I came to the conclusion that the conditions were not enforceable. But they were all differently phrased.
Thank you for that, Roddy. And then Sandra back in.
In terms of the role of the Lands Tribunal and the question if you take applications to the Land Tribunal now, the rule that the loser would be expected to pay the winner's expenses. Do you have any thoughts on that in terms of the Title and Conditions Act, and whether the change in arrangements is beneficial, or perhaps you just expand on that point?
I have experience of appearing at the Lands Tribunal as an expert witness a number of times. The problem is this: under the old scheme, if somebody applied to the Lands Tribunal to vary a title condition, some ancient title conditions, to allow them to, let's say, build another house, and they had fallen out with their neighbour, because as Lionel says, you know, neighbourhood disputes have their roots not in the Title Conditions Scotland Act. People don't actually sit at home at night reading the Title Conditions Scotland Act and saying, I must go and see my neighbour about this. You know, what happens is his dog ate her hamster in 1995, and henceforth it has been war. That's when they go to their lawyers and talk about fences and things like that. So let's say you want to build this extra house, and there's a title condition that says no more building, and you've got an enormous garden, and it wouldn't matter, but the neighbour knows there's a burden that applies to them both, so it's section 52, and away we go. So you apply to the tribunal, and they write in a 3-line objection, or a 1.5-page objection. Under the old law, it had to be considered. There was no scope for saying that's rubbish. It had to go to the full distance, and the tribunal take a look at it and say, well, no, this is perfectly reasonable. We waive the condition. So it's all been held up. You've had a big bill, etc. But the man next door who writes the 1.5 pages doesn't pay your expenses. The other side, of course, of the coin is this. Last year I was approached by an old client, and because all my clients are old now anyway, but approached and said, look, they're going to build, as it happens, a student residence for Glasgow University. Yeah, I know. And they need a corner about maybe half the size of this room from this Barrett house. We want to object. The Barrett people round about don't want a student residence here. They think it will be noisy, they think there will be beer cans, etc., etc. So there's a burden prohibiting in the Barrett title extra building. So this corner would be affected. So it could hold up the whole thing. So they say, we want to object. The builders are applying to the Lands Tribunal to waive this, and we want to object. Have we grounds? And I say, well, you may well have grounds. There are amenity issues here, and there are the factors in section 100 all to be considered. But I said just one thing before you go any further. You need a fighting fund. What do you mean a fighting fund? Well, first of all, you need to get a surveyor to say whether your houses are going to be affected value-wise, so you pay for him. Then you need a fighting fund for legal expenses, because you'll need to appoint somebody to appear in front of the Commission, because they'll have counsel and they'll have architects and they'll have surveyors and experts coming. And I said, oh, by the way, if you lose, you better have at least 50 grand. It will not surprise you to know that opposition then melted away, and they did not object at the tribunal. So it went through as an unopposed objection. Now, there's two ways you can argue this. You can say, that's quite right. Why should a group of little people with a wee agenda of their own, anti-student agenda of their own, why should they stop a much-needed student residence? Or you could say, why should these people living happily in their houses, why should they not be entitled to enforce a title condition that was in all these titles when they bought? Why should they not be? And why should it be that it's money that makes the decision? But to be frank, that is a problem that besets civil litigation generally. Nobody can afford to sneeze in the Court of Session unless you have 10 grand. You know, I mean, that's a fact. And it's a fact at the Lands Tribunal too. So, I mean, these are the two opposing views on it. Personally, I was in favour of having expenses, because it means that you can, you know, anybody can hold up something and know it's not going to be at a cost to them.
Would there not be a sifting process, perhaps, before that, so that people could be forewarned? Surely, or even council usually says prospects of success. And I don't know how you would deal with this, but if they're, you know, if they're given a reasonable prospect of success, on that basis, you know, is there any way that there could be no expenses, you know, each paid their own?
The tribunal can award as it sees fit, but the section says it shall have regard to the normal principle that expenses follow success, i.e., if you win, the other lot pay your expenses.
But there's discretion.
Yeah, I mean, the last time I appeared in front of the tribunal, it wasn't on a variation in discharge. It was on a rectification by the keeper in the land register, and the keeper rectified against the proprietor, and the proprietor appealed against that, and it lasted for days, and the proprietor lost and the keeper won, and the tribunal awarded all the expenses against the party, and I was surprised, but they did.
Very sobering, isn't it? You've gone awfully quiet to stop all these expenses.
For the keeper, there was another expert, gave expert evidence for the applicant, and the keeper won. And but the other side went down, and the council was involved as well, and there was a case about a tomb in Edinburgh. Remember? A tomb? Oh, yes. A tomb.
I'm still with a hamster, but we're now a tomb. Yes,
tomb.
a tomb.
I lead a very varied life. And so they went down for their own counsel, their own solicitor, the keeper's counsel, the keeper's expert, the local authorities council, the local authorities, they went down for all of it.
And there's no compensation payable to anyone who has, let's take your Barrett's people, there'd be no compensation payable for loss of what they thought was a loss of amenity by this land beside them. There'd be no compensation.
There is a provision that would allow the Lands Tribunal to award compensation. I wouldn't have thought, frankly, in that case, in the Barrett House, that there would have been any grounds for compensation.
Professor Reid.
Yeah, I wonder if I just add to this. I take a slightly different view from Professor Rennie on this. I think I am quite concerned at the way the expenses rule is operating. If you bear in mind what the situation is that somebody has got a title provision which says you can't do something. They want to be relieved of that title provision. So they're asking the court to give them something they don't have at the moment. They're asking a favour, as it were. This is not like ordinary civil litigation where you have a right, which you are simply going to the court to enforce. This is a case where you have no right. You're simply going to the court and saying, could you please relieve me of this obligation? And then your neighbours oppose it for reasons which can be good or bad. To apply the same rule of the expenses follows success to that situation as one would apply to ordinary civil litigation does seem to me to be problematic. It skews the situation so much the other way, because as Professor Rennie says, I mean, I've been in exactly the same situation a number of times, advising people and saying to them, to neighbours, that you cannot sensibly oppose this unless you have a lot of money. The consequence of not opposing a development next door to which you don't like, the consequence of not opposing it is the tribunal, under the legislation, has to grant it without further inquiry. In other words, if you don't oppose, then the developer, if it is a developer, simply wins. So the only way you can actually get into court to have the tribunal decide on the merits whether they should go ahead or not is if you're willing to take the risk that if you lose, you're going to be landing with a lot of money. And I think I find this troublesome.
Mr Moss, do you wish to add to that?
No, I have no further comment.
You say it's troublesome, but is this isn't really an issue we could deal with in this bill?
Well, it's in this is a result of something in the Title Conditions Act, because the Title Conditions Act changed the rule. The previous rule was, as Professor Rennie said, that if you defended an application unsuccessfully, you would not normally be liable for the expenses of the other side. You would have to pay your own expenses, but you wouldn't have to pay the cost of senior counsel, etc., engaged by the developer on the other side. And so, and very often in these cases, when you oppose, you're actually not legally represented, so there are no expenses. Whereas what has happened under the Title Conditions Act is that the rule is that if you lose, you have to pay the expenses of the other side, normally.
So that is something we should also attend to in your view.
Well, yes, if you regard that as a good argument, it's something which would come within this inquiry that you're having. Yes.
Thank you very much. Roddy, yes, and I've got Sandra.
There is no kind of academic analysis of the impact of the Act in that respect in terms of expenses. So kind of pre the Act and post the Act, rather than talking about it in theoretical terms. You know.
No research has been carried out. No, both Professor Rennie and I have seen a lot of this going through. We both, I'm sure, have given advice on many occasions, but nobody has done systematic analysis.
Thank you for that question. And Sandra, last question, please.
Thank you very much. Convenient, it wasn't actually on that, but I can't let it go, I'm afraid. I need to supplement it to Roddy's one.
Actually, just have done it.
Well, I'm very honest, and I like to say that as well. I would like to see an analysis of, before the Act came in, just how many appeals were in, or cases went to Land Tribunal, and then since this, I think, unjust and unfair, part of the Act came in, where people have to pay the money. And the reason I say that is obviously a conflict of interest, perhaps in this particular one, as I was very involved in the action that Professor Rennie mentions, the pewter pot one. And if I could just give an example, would you say that the Act works well then, in the fact, not the Act, but in this case, the Land Tribunal, when a developer can buy a house within a development, the sole purpose of to knock that house down once he has changed, it has been changed in the Land Tribunal, and then build student flats on that piece of land. Now, I find it very difficult to take that on board as being just and fair when the objectors who live within the development, whose light is blocked out, and I'm not going through the whole thing, I'm sure Professor Rennie knows more about it than I do, have no right to go forward with it because the cost is prohibitive. So I do think we need to look at the situation in the Land Tribunal Act, and obviously as someone who tried to put forward a bill for community right of appeal and third party right of appeal, I have an interest in that. I think it's unjust that people can't go through with it. But that's just a comment that I wanted to make. But
it's worthy of a question. Is there any response to
One response. If you think about planning consent, I mean, obviously to build a new building, you need planning permission. Neighbours are entitled to object to the grant of planning permission, and often do so. If they do, they're not liable, and they're unsuccessful. They're not then liable for the whole expenses of the planning application of the developer. And I think that of course, is absolutely right. And it seems very odd that you can object to a grant of planning permission without financial liability, but you can't object to getting the title conditions changed without financial liability.
thank you for that clarification.
What's your question?
Oh, I think Mr. Moss wants to come in.
Mr. Moss?
Yes, can I just make one point? I don't know how relevant it is, but it comes back to this point about communication amongst owners and education. I was involved in for a group of, they were actually tenants who owned these, I don't know how you would describe them, hutters, I suppose. They were up at Loch Head, and they were going to get removed. And there was one or two people who went round and collected the fund and ran the thing, and we were successful. We went to the Court of Succession and we were successful, and we got them a renewal of their leases. Now, I know it's different, but what I'm bringing out is that with good communication and with good education, that these things can be resolved.
If you need £50,000.
Well, it depends how many owners there were.
It could be the same thing you're talking about landowning companies. If you're next to this huge big block of student flats, your house happens to be behind it, as in the Pewterpot development, and you have no light, if you're further away, you might think, well, it doesn't really bother me, so why should I bother to gather in money or give money? So in that particular case, you know, I've always thought it's pretty unfair that the law changed, that you couldn't go forward, perhaps as the convener mentioned, a sifting process, or dependent on, you know, the size of the development, then it would go to the Land Tribunal, but other ones could be sifted through quicker.
You're giving solutions now, but you're not asking a question. I want a question.
My question actually wasn't on the Land Tribunal, but Rod had brought it up, and that's why I had to ask that question. My question was actually on switching or changing factors, and what the panel thought of that. I mean, I've read the submissions, the 30-year tie-in for right to buy, and the two-thirds majority. Most of the evidence we've had back, but I must say we've not had an awful lot of evidence here in the committee from tenants and residents. It's mostly been from factors and developers, so I'd like to look at that maybe further within the committee. But what is your opinion? Do you think the two-thirds to change or switch factors is fair, and the 30-year tie-in rule for, you know, right to buy, is that fair, or should that be looked at again?
Could I just respond by saying, I noticed, having read the evidence from last week as well, the rule is not normally two-thirds. The rule is normally a simple majority. There's a misunderstanding about this. The two-thirds rule is simply this, that the default rule is a simple majority. Title deeds can change that. They can increase the size of the majority if they wish. And what the Act says is, if they do that, they cannot increase it beyond two-thirds. So two-thirds is the very worst you can be in. But it's actually not the normal case. Normally, title deeds don't say anything. And the rule is simply, you do it by simple majority. So the rule is by majority. That strikes me as being correct and a sensible and reasonable rule. On the 30-year position of local authorities, that was put in because council houses sell over a very long period. And it was felt there was a difference between a typical developer who sells out a housing estate within 3 or 4 years, on the one hand, at least before the recession, and a local authority which will take years and years to sell council housing. So that was the reason for the difference. Whether it's too long, I don't know. Maybe others have views on that.
I don't think it's too long, and it applies, correct me if I'm wrong, Kenneth, it applies, the 30 years doesn't run from 2004.
No, it doesn't.
The 30 years runs from the time that they were appointed in the deed of conditions. Now, the right to buy has been with us since 1981. So there will be now blocks of flats, houses, where the 30 years is gone.
Oh, yes, Mr Most.
Sorry. It was just on following on from Ms White's comment about the lack of representation of residents' associations, and I remember from my my participation in the steering group for the 2011 Act that, or the voluntary group that preceded it, that the factors there anecdotally were saying that they had a better relationship with owners where there was a residents' association, where people took ownership with a small o of their own development, their own scheme, their own building. And, you know, I would certainly commend the committee to promote, you know, the use of residents' association, because that creates good communication. Where there's good communication, there's a good relationship with the factory, and where there's a good relationship with the factory of a well-maintained scheme or building.
Just a very small follow-up to the fact about, obviously, the majority ownership. In some cases, developers own blocks within blocks, and RSLs own, you know, blocks within blocks, and they end up the majority, so it's impossible to change. Do you think that should be looked at, that they have a vote each, as in a block vote?
We don't know how common that is. I mean, it would be very easy to deal with it. You could simply have a rule which would say that one person cannot hold the majority, so you would need at least one other person. I mean, that would require an amendment, but it could be done very simply. I'm not sure, though, how big a problem this is in practice.
So, Rennie, you don't wish to comment on that, do you?
My firm act for a number of RSLs, and there are, I think, some tenants who will always complain, but by and large, our experience has been that they run things pretty well, factoring-wise, local authorities and other RSLs. And the 30-year rule is there because of the practicality. If you are an RSL with a number of tenants in a block of flats and a number of owner-occupiers, and work needs done, frankly, the best chance of getting that work done is if the RSL take control. I accept that some people in the block will always say, no, I'm not paying, that wasn't necessary, I'm in the 3rd floor, I don't care what happens in the 7th floor. But that's just life. But by and large, I think the record is quite good for RSLs in factoring.
Well, can I thank you? That concludes the evidence session. Can I thank the witnesses for their evidence, which was informative. I don't have a conveyancing headache, though I did become a court lawyer. And it was also entertaining, which was a pleasant surprise. I have to say to the panel and to Mr Most, we wouldn't be making any judgments ourselves. What we'll do is, if we decide to write a report, then we would make recommendations to the government to take forward the issues that all our panels have raised. Thank you very much. Thank you. I suspend for 2 minutes, simply.